May I please your lordship? I beg to mention item number 9. The matter may be passed over for the day. My lord,
Wait till the
my
matter is
senior
called,
has
then
come-
you make your prayer.
my senior has doctor's appointment.
Without looking at the record, we are not adjourning any old matter.
Obliged. May I please, your lordship? Lordship, I beg to mention item number 4, your lordship. We have submitted adjournments leave, your
But
lordship.
this is 2019 matter.
Lordship, Arguing Council is on leave, your lordship.
What says item 4, what says represented, that is submitted that the council holding the brief is on leave. Stop. Matter stands adjourned today. List matter again on 10/3/2026.
May I please, your
My
lordship?
lord,
I need some accommodation in item number 10 and 11. The matter is substantially heard by court number 1. Only the reply is pending.
Okay, this for the transport fund, yes, we are informed of it. What says the representative? It is submitted that the matter has been substantially heard by DB1. Yes, no. Accordingly, matter stands adjourned today. This is the matter before the
The date may be fixed.
we are not fixing a date. You make a mention. We are not giving a date for the Chief Justice.
Obliged.
List after week.
Obliged.
I may appeal also. I may be allowed to go through the record item number 7.
7.
Yes. Yes.
Daily list item 1 for admission.
Yes.
May I please, your lordship? Lordship, in this matter already with some citation, a written argument we have furnished me lord. And another written argument we have prepared me lord. With the lordship permission, I have to place me lord. I go to line by line.
Earlier written argument we don't have.
Milord, lordship, I can, lordship permits me, this is my lord. This is what the decision. Since my lord, only I have one at this day. And the whole facts narrated me lord on chronological. Yes.
Make copies and then give it to us.
Yes, my lord. Here, my lord, The present petitioner is the son of the victim, Azizur Rahman Milot, late Azizur Rahman. And my father,
Just one. Yes.
yes, Lordship, in my petition, Milot, we have enclosed the affair and the inquiry report. Affair at page 14, Milot. The affair lost by my mother, Milot. Saliha Khatun, the victim's wife, Milot. At page 14, Milot. And affair lost on Milot 8/7/2012. And my father was picked up on 7/7/12 night about 12:30 p.m. Inquiry report at page 19, Milot. An inquiry report has been done by Milot Learned Additional District Magistrate on 27 2012. The relevant person recorded at page 25. In public hearing done, my lord. Page 25, my lord. First paragraph.
Yes.
Yes. My lord, this is an inquiry report, my lord, at page 25, my lord. Certain evidence, where eyewitnesses evidence was also taken. And they specifically named that the concerned officer, my lord, that having a Mongolian look, came around the table and twisted the head of the Azizur Rahman. This is the statement, my lord. And it's also corroborated subsequently the evidence recorded under petition of the 176 petition, my lord. Three witnesses, namely, my lord. Mohibur Rahman, Tajuddin, and Sahiduddin. There are three witnesses. Then, my lord, after this inquiry report, my lord, in the meantime, present petition before the principal secretary home, my lord, we made
Who were the eyewitnesses?
three witnesses, my lord, at page 25.
Name?
Namely, my lord, Muhammad Mohibur Rahman, number 2, my lord, Muhammad Tajuddin, and thirdly, Mr. Muhammad Sahiduddin. Only particular this paragraph, is your lordship due permission, I like to read, my lord. On 12/7/12, in response to the notice of public hearing, 7 persons appeared. That is Ilyas Ali, Muhammad Sahibuddin, Kurman Ali, Rafiquddin, and Mohibur Rahman, Tajuddin, and Sahiduddin. And their statements were recorded by annexure number so and so respectively. In the course of their statements, nobody did point out any police access while picking up the Azizur Rahman. However, Muhammad Mohibur Rahman, Tajuddin, and Muhammad Sahiduddin stated in their respective statement that they together had watched hiding in the shadow of the trees on the side of the pond in the house of premises in the opposite of PP, that one police having Mongolian look came around the table and twisted the head of the Azizur Rahman. In the act, two other police kept Azizur Rahman immobile by catching hold of his two hands. This forceful twisting of head resulted complete collapse of Azizur Rahman as he was seen leaned by his side, stated by the aforesaid 3 persons. The father stated, having seen Azizur Rahman lean by his side, the police carried him to the vehicle nearby and spent away. This is the statement recorded by the officer. Then I'd like to draw your lordship attention, my lord. Respondent number 1, my lord. Affidavit preferred, that is Joint Secretary, my lord, at page 81. And enclose the provisional postmortem report as Annexure A at page 87. And page 80 specifically, my lord, the brain and spinal cord, serial number 3. Brain healthy, WT brain so and so, spinal cord not examined, as vertebrate found healthy. That means spinal cord not examined.
What do you want to infer from that?
My lord,
What do you want to infer from that?
uh, twisted his head, my lord. But no injury is there, twisted, and it is also, I will come, my lord, it is all reflected also from evidence of the other witnesses. And some, at page 96 is the
We
report,
are asking you, you have shown us a particular entry.
my lord.
What do you want to infer? What do you want to infer from that?
They're getting spinal cord, my lord.
But what do you want to convey to us?
It is the report, my lord. They simply said that the spinal cord not examined as vertebrae and found, they found disease. Ultimately, their report is at page at 96, that the death was syncope following acute or chronic coronary insufficiency. That is the report at page 96.
Yes.
Then I look to draw your lordship attention, my lord. My lord, in that concern, that affidavit, my lord, only one paragraph, my lord, page 84, paragraph 4F. Some contradictory statement, my lord. Page 84, para F, 4F.
Just a moment.
Ahí go.
84.
Yes, my lord. Page 84, paragraph 4F. Yes. It is stated that during investigation, the investigating officer, among other, Dr. Soman Bhomik, Kaline FRU, and recorded his statement under 161 CRPC. In his statement, Dr. Bhomik stated that on 7/7/12 at about 1:50 a.m., Azizur Rahman was brought to Kaline FRU in serious condition. His blood pressure and pulse were low. He examined Azizur Rahman and gave an injection. Suddenly, he got heart attack. Hence, referred him to Silchar Medical College Hospital. He did not find any torture mark in the Azizur Rahman's body. The Dr. Bhomik clearly mentioned that due to sudden heart failure, his health condition was deteriorated. But this statement is silent. Of the Suman Bhomik's medical report, it is silent, my lord, regarding heart attack is concerned, my lord. I will show your lordship. But it is now, my lord, I have enclosed all this medical prescription, inquiry report. Lordship, kindly have take my additional affidavit, page 99. Page 99 is my additional affidavit, my lord, and NHRA 109, that is Suman Bhomik's medical registers report, my lord. First of all, my lord, also will find starting first in serial number 194, page number 94, 896, it is then. But subwise thereafter, my lord, it is then against 896, 1:50, it is written, Azizur Rahman, so and so, so and so. Initially written, Azizur Rahman brought that. Thereafter, it is wiped out. And secondly, thereafter, this report. This is also asked by the magistrate subsequently in the evidence. I will show your lordship why he has done this. Initial report, why he has deleted. In findings, it is written the pulse is gasping, pulse feeble, BP not recordable. Considering the conditions of the Sancho, I refer to the Sancho. But regarding heart attack is absolutely silent here. BP not recordable.
Yes.
Yeah. By the very next page, 110, page 46, Annexure B. We made an application for under 176 IA, my lord, for further report, my lord. Ultimately, my lord, inquiry has been done at page 46 and page 47. I'll have to take your lordship, kind attention, page 47, serial number 6. During the inquiry, the following witnesses are examined. 1, 2, 3 are the prime witness. Lordship has already mentioned Mohibur, Tajuddin, and Sahid Uddin. The evidence was also taken, my lord. Altogether, 14 witnesses taken, my lord. I will read, my lord. Witness number 1, 2, 3. Dr. Somik Bhomik, this is witness number 7. And witness number Badrul Islam Barbhuya, who was along with respondent number 6 when my father was picked up, my lord. Additional affidavit. First, very first. Yes. Paragraph 8, the evidence below. The statement of the persons examined during the inquiry. The witness Mohibur Rahman, Mohibur stated that on 6/7/12 at night around 1 a.m., he heard cries in the house of his neighbor Azizur Rahman. He woke up and went to the house of Azizur Rahman. He was informed by the gathering that about few moments earlier, 5 police took away Azizur Rahman after assaulting him. As there was a curfew in the area, he, along with Tajuddin and Sahiduddin, went towards the Kalan police post by village road. Then they set towards the western side of the post near a pond. They saw that police set Ajizur on a red plastic chair and arguing with him. Suddenly, 2 police held the leg of the Ajizur and 1 tribal police officer held the head and face of the Ajizur and gave a jerk. Then Ajizur fell towards right. After 4-5 minutes, police took Azizur by a vehicle. Later on, he came to know that Azizur died. He informed the family members of Azizur. This is a statement of Mohibur. Next, Tajuddin Milot. Tajuddin Borvia said that on so-and-so midnight, Mohibur came to his house and called him. He was informed by Mohibur that police has taken Azizur to Kalan police station post. Then they went to the house of Asaruddin. They could not find Asaruddin and informed the incident to Sahiduddin. Thereafter, all of them went towards the Kalan police station post and stood near a pond in front of the post situated near house. Then they saw that the policeman and Azizur Rahman engaged in the altercation. They saw that Azizur was sitting on a red plastic chair. Suddenly, they saw that 2 policemen held both the legs of the Azizur. Then a tribal police officer held the face and head of the Azizur by both the hands and gave a jerk. Then Azizur leaned towards the right. Then 2 policemen took the Azizur to a vehicle. On the next day, they came to know about Azizur dead.
What was the age of the deceased?
Milot, 60.
60.
60. And number 3, Milot, Sahiduddin evidence. Sahiduddin said that on so-and-so Mohibur Rahman and Tajuddin called his brother at around 12:30 night. At that time, his brother Asaruddin was not in the home. He came out and he was told by the 2 that the Azizur was taken to the Kalas police outpost. Then they went towards the Kalan police outpost by village road and they stood opposite the post near a pond. They saw that the Aziz was sitting in armed chair and the police at altercating with the Azizur. Then 2 policemen held Azizur by his legs and then a tribal police held Azizur by the face and head and gave a jerk. Azizur leaned up and fell down. After 4-5 minutes, the 2 policemen took Azizur by a vehicle. Then Mohibur informed the family members Azizur. On the next morning, they came to know about Azizur died. Now, my lord, witness number 5, investigating officer Muhammad Sofiul Hussain. On 10/8/12, DIG has entrusted him with the investigation of the case. On 13/8/12, he deputed the constable to collect the Vishkra report of the FSL Kailipara. The constable informed that within 7 days, the report will be furnished. On so-and-so, Sajal Pal visited the place of occurrence, examined complainant Saliha Begum, my mother, Milot, Saliha Begum, Rajia Begum, Alimuddin, Mehbur so-and-so, Tajuddin, Mohibur and Sahiduddin, Abdul Haq, Mustaq Ali, so-and-so. And
Sir,
another
just a
person,
moment.
constable.
Just a moment. Yes.
Yes, my lord, I will read from Kathigora PS. The Kathigora PS case number so GD entry number so reflect that YT Getsto IPS with his staff has returned to the post with suspect Ajiju Rahman. GD entry number so reflect that Ajiju Rahman fell sick before interrogation and hence he was sent to Kalain Gove Hospital accompanied with SP IPS YT Gestro L. Soikia along with Dr. S. Bhomik was the doctor of Kalain Hospital and who examined the Ajiju Rahman. On so at 1:50 AM, doctor referred the Ajiju Rahman to Casualty Department of SMCH. The certified copy of the register showing the relevant entry dated so in the case diary. Ajiju Rahman was brought to the Kalain PP for interrogation and he was not brought on arrest. No family members, relatives, or friends accompanied Ajijur while brought to the post. As per the statement recorded by the IO, Lekhek Soikia, Badrul Islam, Syamal Chakraborty, and Dilip Kumar Yadav, these are Anamika Burman, are the persons who accompanied the team to apprehend Azizur Rahman. And so Lely Singh was on the sentry duty and so LCD duty. As per the Khungur OP GD entry so dated so mentioned that Azizur Rahman dead and preparation is being made for the inquest and postmortem examination. Dr. Gunojit Das has conducted the postmortem on the dead body of the deceased Azizur Rahman so. My lord, the very important evidence of the Somik Bhomik at page 116.
Just a moment.
Yes, my lord.
There are students here from college. Please kindly stand up. Who are the students in this courtroom? Yes. We would like to tell you that this is a case which is in which the petitioner alleges that the deceased was tortured by the police, resultantly the deceased died, which obviously is being denied by the state. So please hear the matter very carefully, because this is not normally, it's not a normal and routine cases which are being taken up. So please try to understand what is going on, especially the submissions of both sides. Please take note of it. Yes.
116, my lord, the evidence of Dr. Sobik Bhomik. Witness number 7. On 8/12/10/12, Dr. Soman Bhomik, FRU is examined. His version is summarized as hereunder. He is working in the Kalan FRU earlier. It was CHE since the year 2001. He was brought with him the register of the hospital containing the entries since 4/11/11 to 7/7/12 at 1:50 a.m. On 6/7/12, he was in emergency duty, and Srimati Romala Chakraborty, staff nurse, was also in emergency duty. As per register brought by him, Azizur Rahman was brought to the hospital at 1:50 a.m. During arrival of Azizur Rahman, he found Azizur gasping. The pulse was feeble, the PP not recordable. He observed the patient and gave the injection Dexona. He tried to improve the condition of the patient. He noticed that the condition of the patient is serious. Without wasting any time, he referred the patient to Silchar Medical College and Hospital. At 2:15 a.m., the patient left the hospital. Mr. L. Soikia, Kasar YT Gastro, IPS, and others accompanied the patient. When he was asked for comment that there is some deletion of writing above the report of Azizur Rahman in page 194 of the register, he said that he has no idea why there is deletion. It's important, my lord. He has not seen sign of external injury on the person of Azizur Rahman. No family members of the patient accompanied to hospital. There is an ambulance service in the hospital. At that time, oxygen was not available in the ambulance. There was no time to wait and call for an ambulance having oxygen facility. By vehicle of the police of Kaline, the patient was sent from Kaline to Silchar Medical College Hospital. This is very important. Without having oxygen ambulance, my father was referred to Silchar Medical College Hospital. And during his duty patrol period, 6/7/12 at 11:50 a.m., he examined one Kartik Re, a patient whose entry number 895, entry number 896 also made by him on censure. He has not taken any steps to find out as who deleted a portion of the entry made above the entry 896, my lord. So, my lord, from this evidence, it is clear, my lord, even he said that who has deleted this, since he is the concern of officer, Dr. Milot, who maintained this registry, but he himself saying who deleted this, he don't know. And secondly, Milot, when he found my serious condition of my father, Milot, there's no oxygen facility available at that time, Milot. So instead of sending my father in the ambulance, in the police vehicle where my father was brought from police outpost, from that vehicle, my father was referred to Silchar Medical College Hospital. This is reflected from the evidence, Milot. Now, Milot, the findings of the, ultimately, Milot, another witness is very important who was accompanied on that when my father was picked up, Milot, at page 117, witness number 9, that is Badrul Islam Borbian. This is very important, my lord, his evidence. At that night, at 6/7/12, he went along with IPS officer YT Gastro for a raid at Bortolal Part 2 Sensor, then went out of the police post by Bolero vehicle of the IPS officer. They went to the house of Nizamuddin. After picking the
Mr. Dekar,
my lord,
there are two facets in this case.
My lord.
What you have read.
my lord.
Number one, there's allegation of police torture.
My lord.
We are concentrating on that.
Yes, my lord.
The second aspect which you have now highlighted is that there was no oxygen, and therefore this witness says that instead of waiting for the oxygen and ambulance, he was sent on a
Police vehicle.
police vehicle. That amounts to negligence. It doesn't, this is not a part of torture by the police.
Absolutely, my lord. The negligence. Yes, lordship,
Are you,
correct.
And we are perhaps not hearing the issue of negligence by the authorities, which resulted in the manner in which he was sent.
Yes, my lord.
Are you, what do you call, are you pressing for both?
No, I'm
Number one, police torture, and number two, negligence on part of the hospital
I'm
authorities?
concerned of police torture, my lord. Yes, my lord. Then, my lord, the findings of the concerned judicial officer at page 121, serial number 11, ultimate findings of the inquiry. In the inquiry, the witnesses who seem to be material are examined. The deceased Azizur Rahman was brought to the Kalan police station post in the night so-and-so, as his son was not found in the house. The Kalan petrol post GD entry number so-and-so dated so-and-so reflect that IPS officer Y. Gastro, Deputy SP headquarters, had left the post for apprehending the accused in connection with the category PS case number so-and-so. The deceased Azizur Rahman was not brought to the Kalan petrol post as an accused, but he was brought to the post so that he can bring his son to the post. The arresting authority police has not followed the provisions of section 50 and 50A of the Code of Criminal Procedure while bringing the deceased to the post. Badrul Islam Borbiya, who accompanied the team to the house of the deceased Azizur, said that IPS officer informed deceased that he was also identified in the video recording in the incident on 4/7/12. The IO of the category PS case so-and-so has said that till 12/11/12, there is no evidence that deceased was identified in any video recording. That the witness Mohibur Rahman stated before the inquiry that the witness the torture on Azizur in the post and informed to the family members of the deceased. On which date he informed the family members of the deceased is not clear. The deceased was brought there to the Silchar Medical College Hospital. The examination of the dead body was done within 24 hours of that. The witnesses who who claimed to notice the torture on the deceased has not named the tormentors. During the inquiry, the doctor who conducted the postmortem of the deceased narrated in details the way in examination is done. On being questioned whether there is any chance of getting fracture of neck bones if X-ray is done after postmortem examination, he said that the chances is very negligible or almost nil. The statement was given by the doctor before receiving the report of forensic examination of X-ray. After receiving the FSL report, Dr. Sharma, head of the Department of Cardiology, Silchar Medical College Hospital, was examined as an expert. He said that cholesterol and arteriosclerosis develops from late childhood and adulthood, which hampers blood flow in the coronary artery. It means it may remain asymptomatic. The sudden spasms of the disposition of the blood clot causes arrest of the blood supply to the heart, which is called acute coronary insufficiency. When there is acute coronary insufficiency, the heart may stop functioning suddenly, and that may cause arrest of blood supply to the brain. Finally, the Dr. Suman Bhomik, who examined and treated the deceased on the night of incident, said deceased Azizur Rahman was brought to the Kalan FRU by Kalan PS at 1:50 am. He said that patient was gasping, the pulse was feeble, BP not recordable, and he gave the injection, Dexona, and tried to improve the condition of the patient. He noticed that the condition of the patient was serious. He referred the patient to SMCs that he places before the inquiry, the register, where the entries of patients' examines are made. Before the entry regarding Azizur Rahman, entry number so-and-so, there is a deletion of some writings. The doctor does not know who deleted the contents. The contents so deleted cannot be read, or that the same was in connection with the disease cannot be deduced. The report of the doctor, postmortem report and FSL report does not reveal that there was injury on the person of the deceased. As per the examination of the dead body was done within 24 hours of the death. The doctor has examined detailed the manner of the postmortem. There was no scope for disinterment of the dead body. So regarding the cause of death of the deceased, the same is not due to any injury on the person of the deceased. This is a finding of the report of the
Which page is that postmortem report?
postmortem report, Lordship, at page 87, enclosed by the respondent number 1 in his affidavit, my lord. This is provisional postmortem, as per their statement. Blood supply to Cinco. Blood supply. Almost. Post type বলে। Cinco. Loss of consciousness. Loss of power. Guided by fear, pain. Yes. Okay. Google. Negligence, fear, or pain. my lord, since to ultimate their findings that my cause of my death of my father is the syncope. That is, as per there is no external injury, my lord. If your lordship, the syncope, they have decided it is the exactly meaning, my lord. What is exactly syncope, my lord? The syncope, my lord, it is stated, my lord, that a temporary loss of consciousness and muscle tone followed by spontaneous recovery. But cause, how it is caused the syncope? The most common form of physiological syncope, they're triggered by fear, pain, or standing too long. That means, admittedly, my father was not brought as an accused to the police station. And thus, just suddenly at 12 and at 30 p.m., my lord, my father was healthy condition at that time, my lord. And 12 at 30 p.m., they brought my father. After they tortured my father, and three eyewitnesses have seen, my lord, how the concerned officer had jerked his head on the table and two other pulling his legs, my lord. Ultimately, my father died in the outpost. That mere formality, they brought my father to the police outpost station, my lord. So, my lord, since it is the nature of syncope disease, my lord, how it is external injury is reflect, my lord. He was a very normal person at the time of incident, my lord. And he's not an accused person, thus to clear his son, my lord, where son is about. And therefore, he was brought even without following the section 1550A of the CRPC provisions, my lord. So it is the absolutely, my father lost his life, thus because torture in the outpost, the police station, my lord. So petitioner made in this case, petition made regarding compensation in this matter. So oblige, my lord. My lord, perhaps my all. It is not, they have submitted me on a provisional postmortem, but final original postmortem report perhaps in the records, my lord. My learned friend might help me out.
It is there, bro, only because of the FSL final outcome. The FSL final outcome is there, Manoj. I'm just indicating.
It'll merely say not poisoning, not a case of poisoning.
Yes, yes, after that, the report has been given. The FSL report. It is in the affidavit of respondent number 1, Manoj. Page number 90, 91, Manoj.
No poison.
No poison.
But Mr. Nat,
Lordship.
not for this particular case,
Malak.
but I think you should have a word with the health department.
Malak.
Here, in this page 90,
Page Lordship.
you'll find that the opinion regarding death kept pending,
Lordship.
correct? Now
Lordship.
the FSL report has come.
Yes.
That is at page 91 you are showing.
90, Lordship. 96 is the report now, final report.
96.
96. That was the FSL report
This should be there.
and final 96.
Unless this is there, it's not complete.
Lordship.
That's right.
Good. But before I start, Malab,
No, just a moment. Unless I record, I'll forget.
Malab.
Okay. Time machine. Put number 9.
Yes.
Well, before I take your lordship to my final submissions in the matter, but I have with I have to express my little bit of inability, but the writ petition, the entire case projected is different. But by filing two additional affidavits, the case has been changed. The additional pleadings have been done, and now the case projected is totally different. I have applied for the certified copy of those two additional affidavits because somehow it is not in my file. I did not get the copy.
We'll give you this record. We'll give you a record.
Yes, I have requested my friend also. I'll take the copy and kindly accommodate me to make my submissions, final submissions tomorrow. I get the copy today. I have requested him, since this is item number 1, kindly to that extent, kindly accommodate me till tomorrow. Because the writ petition, if lordship see, dates are important, the incident took place in the month of July 2012.
Additional, which affidavits you are requiring?
Lordship, the additional affidavit, one, the petitioner has filed on 10/5/2023. This will be page 99 to 132. And
10/5/23, okay.
10/5/23, 99 to 132. I have checked the record, and another additional affidavit, 4/6/2025, page 171 to 179. Any control?
Yes, okay.
And one affidavit they filed on 29/5/2025, 161 to 170. I have requested my learned friend, he has agreed. He will give me, I'll take the copy and I'll make my final submissions tomorrow. Kindly accommodate me till tomorrow. Because I have to show that the prayer made in the writ petition, because I have submitted that it was happened in the month of July 2012. They filed the writ petition in the year 2015, after 3 years. But what they have brought in the additional affidavit, those were not made part of the writ petition. And in the writ petition, their basic prayer is to conduct an inquiry, DP against the police, issuance of death certificate and PM report, because they were not given the PM report, and adequate compensation. Those are the prayers. Now, in the additional affidavit, so many things they have brought, showing that twisting of head. That is the now main core the point they are urging. I have to just refer to the statements made in the affidavit account. So, kindly, after the affidavits,
Rest of the submission you can conclude so that we don't have to come again.
without referring to these affidavits, it is difficult, but I'll please, what they have said in the writ petition. Can you take up the writ petition, Some paragraphs in the petition are important, my lord. Kindly. After 3 years, on 27 July 2015, they filed this writ petition and they stated, my lord, in para 4, basic, this is their case, that on that Azizur Rahman Khan, that is respondent number 7, is one of the person who opposed the bond because of political rivalry, but the police authority to save him from arrest at around 12:30 a.m. on 7/7/2012 surrounded the residence of innocent Azizur Rahman, father of the petitioner, who was sleeping peacefully at that night. Police was led by YT Gyatso, respondent number 6, and knocked the doors. At the sound of heavy knocks, Azizur Rahman got up and opened the door. Then, violating the norms, started assaulting Azizur Rahman mercilessly. So, merciless assault, their allegation. The old man Azizur Rahman.
Yes, please continue.
Page number 6. I'm reading page number 6, para 4. So their allegation is that police led by YT Gyatso, respondent number 6, and knocked the doors. At the sound of heavy knocks, Azizur Rahman got up and opened the door. Then, violating the norms, started assaulting Azizur Rahman mercilessly. Mercilessly, torture is there according to them. The old man Azizur Rahman cried and pleaded with YT Gyatso, saying that he did not know anything and was not part of the mood. In presence of his wife and daughter. Daughter is important, my lord. Daughter is important. Just kindly take note. YT Gyatso kicked in his ear and back of his head, and then he was dragged by police personnel to police station at that night. So now they said that in the police station, Azizur Rahman was tortured mercilessly again. Although Azizur Rahman was not involved with the incident, nor had a motive motivated by any political party. As a result, Azizur Rahman died, and on the same night while in the police custody. Now, Lord, para number 6, they said, after filing of the FIR, no action has been taken to inquire into the incident and to punish the persons involved in killing of the father of the petitioner. Further, to avoid the incident and to deprive the petitioner from justice, no postmortem report except certificate in Form A has been furnished to the petitioner till date by the respondent authorities. The doctor in charge of postmortem took the viscera from the deceased and sent it for chemical analysis, but till date, no postmortem has been submitted by the respondent authorities. Then in paragraph 7, their allegation is that thereafter the ministerial inquiry was conducted by the additional district magistrate, Kachar Silchar, by memo number so-and-so dated 27/2012. After 13 days, my lord, submitted report before the district magistrate Kachar without any definite conclusion and subject to final report submitted by the Forensic Science Laboratory, Gauhati, but the family of the petitioner was not heard during the inquiry to find out the truth. They have played these stories because that is why, my lord, they are projecting a case and they are praying for CBI inquiry in this case, inquiry by NIA. That is how they have developed the case. Then, my lord, they said the above inquiry is it is clear that the father of the petitioner was forcefully taken by the police as a part of political conspiracy and he died in police custody. My lord, kindly come to para 9, next page. The petitioner begs to state that although a ministerial inquiry is declared by the authority, but it was not properly done, as neither the person, namely Azizur Rahman Khan, Atabur Mazhar Bhuya, YT Gyatso, etc., were questioned, nor the family members of the petitioner were summoned. This has importance because what I am trying to indicate in the inquiry, the daughter of the petitioner was also there, daughter of the victim, the sister of the petitioner. She was there. So their allegation is that nobody was in fact summoned in the inquiry by the inquiry authority, and therefore no action has been taken against the person for whom the father of the petitioner was tortured brutally and he died in police custody. Even the family of the petitioner was not aware about the said ministerial inquiry. They are not aware. Everything has been done as they have projected that everything has been done behind their back. The petitioner further states that that of undue influence by the respondents, particularly the respondent number 6, 7, 8, and 9. On police authority, neither proper inquiry was done nor departmental proceeding drawn up against the police personnel involved in the said incident, for which no action has been taken against any of the police authority, although it is admitted that innocent father of the petitioner was died in police custody. Further, the statement of Ilyas Ali, Sahabuddin, Kurman Ali, Rafiq Uddin, Mahibur Rahman, Tajuddin, and Sahiduddin have never been discussed in the inquiry report dated 27/2012, had deposed torture of police on father of the petitioner. As such, there is possibility of interference of the respondent authorities in conducting inquiry to punish those who are involved in causing death of the father. Then that is again they have said in paragraph 13, Malad, that in the last sentence only I'm indicating, Malad, that para 13 they said that keeping in view the lacuna in law regarding inquiry into the death in police custody incorporated in section 1A in section 176 of Criminal Procedure Code 1973 by section 18(2) of the CRPC Amendment Act 2005, providing for an inquiry by the judicial magistrate in addition to the inquiry or investigation held by the police. During such inquiry, the magistrate shall allow the relatives of the deceased to remain present in the inquiry, but nothing has been done to take opinion of the petitioner's family. Therefore, in para 14, they said that till date, no departmental action has been taken against the police personnel for their lapse in protecting the life of people and further for not taking impartial action during investigation due to failure on the part of the police authority to investigate and to punish the persons due to reasons of incident and death of Azizur Rahman. The respondent authorities are entitled for a direction from this honorable court to investigate the whole incident as well as death of father of the petitioner either by CID or by Central Bureau of Investigation, CID or by Central Bureau of Investigation or by NIA. And now they have said that they are entitled for compensation. So this is the case projected in the petition. My
Do you
respectful
have the case diary of the original case where he was arrested?
In fact, finally charge sheet has been submitted, and it is in their affidavit they have indicated. Charge sheet is it?
He was arrested in connection with Katigora PS case number 291 of 12. Is it right?
Yes,
Arrested in connection with 291 of 12.
291. Yes, para 5.
Or no, 291 would be this cross case of the death.
They have filed.
So where is the previous offense for which he was taken in custody?
Well, in the SP's affidavit, it is there. Malad. Kindly come to page number. It starts at 39. Kindly come to page 40. Page 40, para 5. Para 5. Subsequently, rejection of that's it.
Complaint is registered with
279.
No, Maladi petition of
what as far as it was.
279. Yes. 279 of 2012. No? We have stated that in course of investigation of Katigora PS case number 279 of 12, registered in connection with the above incident, 2 alleged accused were apprehended by police who during the course of interrogation disclosed the name of Muhammad Azizur Rahman and stated that he was an active member of the mob who went berserk at the time of the incident. In that case, there's another case, Malad, we have indicated. Malad. So for the FIR lodged by the lodge. But in the writ petition, one vital document is there, Malad. Annexure A3, Annexure 3, Malad. Annexure 3 at page 28. This is a representation filed by the petitioner on 12/12/2012 before the page 28. Page 28. This is the translated copy. The entire projection is Malad, page 28. The petitioner has filed an application before Principal Secretary Home. Application for impartial inquiry of the death of Azizur Rahman and innocent people in police custody, which is a part of political conspiracy. The entire Malad, I am just trying to persuade Malad, I am trying to place it before your lordship that what now they are urging before the honorable court, there is no whisper, Malad. In fact, the incident took place, the FIR lordship will find at page number 16, the original FIR, translated copy at page 14. Well, in fact, there is no whisper. On 6/7, they said on 6th of July, incident took place. On 8th of July, the FIR was lost. There is no whisper. That 3 villagers have shown that the neck was twisted by one Mongolian face-like officer, and he died at that spot. There is no whisper, not in the writ petition, not in the FIR, not in the representation before the principal secretary. In fact, before the principal secretary, kindly see page 28, what they said, that this is a political conspiracy. He was tortured, and they have in the writ petition also said that the moment the door was opened at his house, Mullah, he was mercilessly beaten. There is no, the postmortem report indicates no injury marks. My humble submission before your lordship is that this is not afterthought. They are just trying to develop this story. Absolutely an afterthought, nothing else. Because in the entire representation, this is in the month of July, this is in the month of December 2012. The FIR was lodged on 8th by the mother. In the month of December 2012, my lord, had it been a case that three villagers, in fact, three villagers in the report, my lord, I remember reading, but just I'll take the copy and I'll again read it tomorrow again. The three names now they are projecting. They said that they're neighbors, and they saw something on that particular night. But had it been the case on 8th itself, it would be they may have indicated something in the FIR. If not, in the month of December 2012, when this petition was filed before the Home Secretary, the Commissioner and Secretary Home, there is nothing, my lord. If I'm page 28, I'm allowed to read, my lord. Respected sir, I beg to state that in reaction to second marriage of Ruminath, a MLA of so-and-so, Hindu Jagaran Manch and so-and-so declared band in Barak Valley. To stop the said ban as per instruction of so-and-so, his so-called nominee, as so-and-so, Ajizur Rahman Khan arranged a meeting of communal workers of AID of so-and-so as a residence on 3/7/2012 at about 3 p.m. wherein Ajizur Rahman Khan presided over the said meeting. It was decided in the meeting to oppose the ban by using lathi and other arms. It is to be mentioned that regional leader Atnapur Rahman Majarhuya shows his communal power to create vote bank and used anti-social elements for outside, which created in Kalayan Bazar. On the day before the ban, persons from both the communities came out. Due to strict action taken by administration, normalcy was retained there, and as a result, no death of innocent people. The person who are responsible for the said incident, Azizur Rahman Khan, Atabur Rahman, Abdul Sahid Kothari, and so-and-so, and other leader of so-and-so. Kalain petrol post is located in a rented house of above named one person, namely Azizur Rahman Khan, and further the IC of the said petrol post, Anwar Hussain Chaudhary, is residing in a rented house of him and have a good relation. After the day of incident of police, the police administration during inquiry started searching Azizur Rahman Khan, but due to political intervention of AIDF party, the OC of so-and-so took Azizur Rahman Khan, who was an innocent, and killed him. Azizur Rahman is an innocent farmer and small businessman and no way associated with any political affair, nor he was a member of any political party. Persons of Hindu and Muslim community respect him. On the day of incident, he was in his residence and never came out. But Azizur Rahman Khan was not arrested, but in his place, Azizur Rahman was arrested and killed him. If the inquiry conducted regarding the personality of Azizur Rahman, then truth will be known. The following persons will depose evidence: mother, wife, son, and daughter of late Azizur Rahman, Noman Uddin Tapadar, Natunpar, number 3, Asad Uddin, number 3, Nuruz Mia, number 4, Nuruz Mia, number 5, Abdul Jalil, 6, Haji Nazmul Hussain, 7, Islamuddin Borhuya, number 8, Jalaluddin Borhuya, number 9, Mohibur Rahman, number 10, Jamaluddin, number 11, Farooq Ahmed, number 12, Jamila Begum, number 13, Saiful Islam, number 14, Akad Das, and public of Kalain. So these are the witness to prove that incident, that he is an innocent person not involved in any of the incident. Without conducting inquiry and as a part of political conspiracy, Azizur Rahman was killed. Therefore, an inquiry is necessary. Present place of police patrol post is required to be changed from Dhamkar located government agriculture market shed, and then no need to pay rent. Here, near to road, 3 sheds are prepared. If the government directs to conduct the impartial inquiry by either CID or CBI, NIA, stated in paragraph 8, along with Azizur Rahman Khan, then clear facts will come out. As a result, actual culprit will be arrested and public peace will be prevailed, and family of Azizur Rahman will get justice. So that is what their grievance. That a person was killed due to political conspiracy, and before the Home Principal Secretary, Home and Political Department in December 2012, they have called it.
This is on the point. Now, he makes a complaint that he has been. Sorry. Now, when affidavit, few years later, he gives a description of how he was. Will it be explanatory or it will be the setting up of a case, as you say?
But my respectful submission before your lordship would be in that case, that what they have brought in the additional affidavit is a vital point. Because they are indicating how the torture was inflicted on the person concerned. It is so vital, Lord, that it will change the entire nature and character of the offense alleged. Matlab, torture in the police custody is different, and matlab, a person is sitting, two persons pulled his leg and one twisted his head. It is absolutely different, matlab, the magnitude of the offense. If something has happened like that. And I am matlab, repeatedly submitting this because they cannot say that the magisterial inquiry is not in our knowledge. Number one, because their sister, she appeared in the inquiry. Number two, the inquiry report is annexed in the writ petition. It is annexure 2, page 19 in the writ petition. Why malab, I am submitting like that? Then that so vital information, malab, now that is the center point of the argument of the petitioner, and no whisper of that in the writ petition and the representation, even if it is in your knowledge. In 2023, file an additional affidavit. Now, malab, that is the main point.
Secondly, you see, in your affidavit filed by this, respondent number 6, recently 9-1,
Lordship.
he admits that the deceased was taken into custody as an accused.
True.
Once he admits that he has taken the person as a accused, then non-compliance of section 50A will invite a disciplinary proceedings.
But that is one aspect. The other aspect is, malab, in the affidavit, he has also said that he was brought, then in patrolling, he went out. He said, malab, because at
12:30 in the night.
at 12:30, at 12:31, because at that point, that curfew was going on. It is a case, malab, it is a case of the petitioner also, that at that particular point of time, there was disturbance, curfew was on. And they are projecting that so-and-so is going there, so-and-so is malab, moving there and here and there. Curfew was there. So the police patrolling was going on. Day and night patrolling was going. In the affidavit, he has said that he brought him malab, at around 12:31, and after that he went out. Then he came to know something has happened, then he come back again. So that is his statement in the, malab, if for violation of section 50, 51, malab, lordship has indicated, malab, that is definitely. But now the FIR has been registered, FIR has been filed. Second FIR, they raise objection, reinvestigation, then again FIR has been filed. Now they have, considering they are Naraji
Dates
petition.
of that FIR, 2 FIRs, is gives the dates.
But in the affidavit which I have indicated, of it starts at page 39, respondent number 4's affidavit. Lordship will come to paragraph, page number 43. Page number 43. Second paragraph. It starts as after collection of final report and completion of investigation. IO Inspector Saiful Hussain, Circle Inspector, Eastern Circle, submitted final report into the case by Kategora PS FR number 144 of 2012 on 29/12/2012 as
FR
missed
number?
of time. FR number 144/12 dated 29/12/2012.
29/12/2012.
12 lots. This is the first FR.
Then objection was raised.
Then objection was raised. then the reinvestigation, then second FR was filed. After second FR, again there is objection. Now a complaint case has been the complaint case has been registered.
Reinvestigated, and second FR was filed on.
That. अपना कहीं तो मसला है। अपना कहीं तो मसला है।
My lord, page 168.
Just give me the number.
Yes, my lord. My lord, we have filed objection on 23/4/25.
What is the number of FR?
FR 32 dated 30/4/2023. Page 168, it is
No,
clear.
no, just give me the.
Yes, my
because
lord.
we don't want to read, but
FR number 32 dated 30/04/2023.
1313.
Yes, my lord. 30 30
30.
30/04/2023.
Objection on.
Objection on 23/4/25.
What is the name of the complaint case? Number of the complaint case?
Yes, my lord. আচ্ছা, pilot আছে. Yeah, it is. I'm giving my lord. Right now.
Take a short, we can come back.
Mas.
Hello, may I submit a complaint copy, my lord? This is copy. Complaint copy. Yes. CR number 507 of 2025. 2025. Pending before the Chief Judicial Magistrate Kasar Silchar. My lord, initial deposition, my lord.
Lordship.
Lordship, I'm afraid Mr. Nath, he had to leave for some urgent matter, Lordship. Some accommodation. My learned friend may continue, Lordship.
Yes, I can continue, my lord.
We are in the midst of a hearing, Lordship.
Petition to the.
Lordship. Lordship. It is Saturday, today আপনার অভিযোগ হবে। packet
Certainly. My lord. Yes, my lord.
tomorrow, Lordship. Tomorrow.
Saturday I have some function Miller at home in the afternoon of Friday. Yes.
Petitioner is concluded, reserving right to reply. Next matter. Mr. D. Nath, the senior government advocate, has submitted that he has made a request to the learned counsel for the petitioner for being supplied with
Okay. No,
copy
no.
of
Wait.
additional affidavit filed by the petitioner on 10/5/2023. Additional affidavit filed by the petitioner on 4/6/2023. However,
এখানে
he has advanced his submissions. Which remains inconclusive. List as a battered matter on 8/6/2026.
Obliged, your lord.
Last minute.
Supply item 14 for admission.
May I please, Your Lordship, my lord, in this case, my lord, I was engaged on 26th of September, my lord. But unfortunately, my name is not reflected in the cause list, my lord. This is an expertise, my lord, order which has been put to challenge, my lord. My lord will kindly come to page 30, my lord. The impugn order, my lord. It was impugn judgment and order, my lord.
Yes.
Yes, my lord. Notice was issued to her, my lord, and she accordingly, my lord, she had engaged on counsel, my lord. And accordingly, my lord, the proceeding was before the, my lord, Foreigners Tribunal at Nogam, my lord. But on subsequent occasion, my lord, that was received on transfer by the jurisdictional tribunal at number 3 at Morigaon, my lord. Thereafter, my lord, the case was continued, my lord. However, my lord, although the petitioner had engaged the counsel, my lord, he did not take, my lord, appropriate steps as per the allegation of the, my lord, earlier counsel, my lord. That I will take your lordship, my lord, to, my lord, directly to page 35, my lord, of my lord, another petition, my lord, which was filed a miss case, my lord, miss case number 12 of 17, my lord. Concerned page is at page 35, my lord. Counsel who was, my lord, engaged in for the second time, my lord, before the learned court below, he took a specific stand at para number 7, my lord. Last bottom para, my lord, that the process server at the time of serving the notice did not explain anything about the notice to the petitioner Zubeda Begum. After receiving the notice, the petitioner Zubeda Begum came to the Moregaon court and met learned advocate so and so, and however handed the notice to the learned advocate. After examination of the notice, the learned advocate advised the petitioner Zubeda Begum to buy a wakalatnama and taking the thumb impression on the wakalatnama in the evening, and after taking advocate's fee, they given the fixing date of the case to the petitioner so and so. The petitioner Zubeda Begum has came to the court on 29th of January 2016 and met the learned advocate and asked them about the progress of the case. The learned advocate told to the petitioner Zubeda Begum to bring the original documents of voter list, land documents, etc. The Zubeda Begum on 3/2/2016 again came to the court and met the learned advocate and hand over all the original documents to them. The petitioner Zubaida Begum on every date of the case came to the court and met the learned engaged advocate, but the learned advocate never appeared the petitioner Zubaida Begum before your honorable court and never filed any hazira on behalf of the petitioner Zubaida Begum. But the petitioner Zubaida Begum in every date of the case was present and met the engaged advocate, and in every date the petitioner given advocate's fee to them. The learned advocate always told the petitioner Zubaida Begum that the case is progress and the result of the case will be positive. Due to the false advice and misguided by the learned advocate, the petitioner Zubaida Begum could not appear before your honorable tribunal and unable to defend the case by filing written statement, documents and adduced evidence in connection with FT case number so and so. The house of the petitioner, there is no telephone and mobile phone, and hence the mother of the petitioner is unable to inform her son so and so, which were living at Kerala at the time of serving the notice and during the time of trial of the case. The Sahida Begum is minor at the time of serving the notice of the above noted case. Therefore, the other petitioner has no any knowledge about the above noted case, and hence the petitioners are unable to appear before your honorable court and file WS documents, evidence in support of their case to prove themselves as an Indian citizen. The petitioners have sufficient documents to prove their Indian citizenship as required under Section 9 of the Foreigners Act 1946. Petitioners belongs to the same family and citizen of India by birth and by permanently resides in Assam before independence of India and regularly enjoying their voter right as an Indian citizen till today. The above noted case was proceeded as expertise due to negligence of the learned advocate who were engaged in the case by the petitioner Zubaida Begum. The petitioner Zubaida Begum has given advocate professional fee to the learned advocate, but they did not trial the case as per provision of law and misled the petitioner, and hence your honorable court by an expertise judgment and order dated 13/6/2016 by declaring the petitioners and other 3 family members as foreigners in connection with the above noted case. That non-appearance of the petitioners before your honorable court was neither willful nor intentional, but due to having no knowledge about the aforesaid case. Thereafter, my lord, I'll take your lordship to the, my lord, order which was passed in the miss case, my lord, page 40, my lord. Yes, my lord will kindly come to page 40, my lord, annex 10, my lord. After filing of this miss case, my lord, separate order was passed by the my lord concerned tribunal, my lord, that your lordship will find at page 40, my lord. In the last paragraph, on the third paragraph, the office appeared with engaged lawyer on receiving the notice and have took maximum number of adjournments to file WS, and since they failed to prosecute their case, the instant case was proceeded against them. The OPs in their miscase have leveled serious allegation against the earlier engaged lawyer and for his misguide, to which the case proceeded against them. But that as may be, the OPs, if aggrieved by the conduct of their engaged lawyer, could easily seek relief against such erring advocate in a different forum. Moreover, the instant case, miscase have been filed after 1 year and therefore is also hit by the limitation period as under Foreigners Order 1964. The time limit is only 30 days from the date the order, and therefore I do not find any merit with instant miscellaneous case to interfere with the order dated so and so. Accordingly, the instant miscellaneous case is dismissed, being devoid of merit. Thereafter, my lord, the petitioner has appeared before your lordship, my lord. Again, on my lord, another separate petition was filed, my lord. That lordship will find at page 42, annexure 11, my lord. Whereby, my lord, there were altogether, my lord, 3 petitioners, my lord, against whom, my lord, there was no reference, and they are the sons and daughter of the, my lord, present petitioner, my lord. Page 42, my lord. And accordingly, by virtue of, my lord, the decision rendered in Sudhir Roy, my lord, a direction was also issued in their case, that adjudication of the matter will lie upon the person concerned against whom a reference is initiated. And there was no reference against all these 3 persons. They are sons and daughters. My humble prayer before your lordship is that she is absolutely an illiterate lady, and an aged person. She is not aware of any consequence. She had met with the concerned advocate, and she had given sufficient explanation in the petition itself, also. My lord will kindly, consider her prayer and at least will provide her, one last opportunity.
What's the
so as to-
relation between 2017 and the present filing of the writ petition?
Yes, my lord, that
9 years, what is the relation?
a gap is there, my lord. A gap is there, my lord. I admit that. And regarding that, my lord, my earlier, my lord, learned friend, my lord, he has made some, my lord, averments in the petition, my lord. Right from, my lord, paragraph, my lord, 20, my lord, page 11 of the petition.
Page number, paragraph?
Para 20, page 11 of the petition, my lord. Para 20, 21 and 22, my lord. He has made some averments. My lord. She has made. And
But
23 also.
English is a very expressive language. Now you use the words that your lawyer informed that the case was proceeding properly. Correct. Now let us test this theory in a case where there is no appearance by the petitioner. The court will say that notice served, petitioner did not appear, case to proceed ex parte. Then it says that the plaintiff will give evidence. Plaintiff gives evidence, no cross-examination. Procedure of cross-examination closed. Next date is for DW. DW, nobody appears. Now, can we say that the proceeding is not properly
No, my lord.
being held?
My lord, I beg apology on behalf of the my lord.
No,
earlier
no, it's
counsel, my
that-
lord. It was never drafted by me.
Case is
Had it been
properly-
drafted by me, my lord, the language
You
would have
did
been
not
different.
contest it, so you'll have to give explanation of not the case being properly conducted. You have to explain us about
Lord.
your absence.
Yes, my lord. At this stage, my lord, where I'm humbly praying before your lordship, my lord, it's just whatever has been pleaded before your lordship, my lord, please cannot be modified, my lord. And for that, my lord, I express my apology before your lordship, my lord. Lordship will kindly consider that part.
To apologize.
And she is, my lord, almost 69 years old, my lord. She could not contest the reference on merit, my lord. Not for the fault of the, my lord, lawyers, my lord. But I'm humbly praying before your lordship, my lord. My lord, her case may kindly be considered that at least one last opportunity should be granted to her, my lord, so as to defend her case and to contest the reference on merit, my lord, before the concerned tribunal, my lord.
Lordship, Lordship, it is not the case that petitioner does not aware about the proceeding, Lordship. And Lordship, even after that also, Lordship, they are very much aware about the opinion passed by the tribunal and what will be the outcome of the that opinion, Lordship. And that is why, Lordship, petitioner sons and daughters has filed this writ petition, Lordship, in the year 2019, Lordship. Since 2019, they came to learn about the law that there must be an independent inquiry in respect of all the proceeding, Lordship. But they forgot to contest the opinion in respect of their mother, Lordship. So, Lordship, it is total negligence on the part of the petitioner. Lordship,
Lady Miller. She was misguided by all along by the Miller trial court advocates Miller. This has been Miller admitted Miller. My lord will kindly Miller provide one last chance Miller. But she will kindly impose Miller some cost Miller. She is ready to bear the cost Miller even. But Miller, her citizenship, when this will go Miller, she will be nowhere Miller. But she will kindly Miller give her Miller some at least one last chance Miller so that she may Miller prove her case.
Your three children, they came and contested the opinion before this court.
yes,
You can't say that the.
That, my lord, that I wholeheartedly admit, my lord, but what I'm playing before your lordship, my lord, these are the, my lord, persons, my lord, who never well aware of the consequences. They are always, my lord, misguided by the trial court advocates, my lord. And my lord, I apologize for that, my lord. On behalf of the, my lord, petitioner, my lord, I'm humbly praying before your lordship, my lord. Lordship will kindly impose any condition, my lord. So, and I'll be appearing before the concerned tribunal within the stipulated time, my lord. One last chance should be provided to, my lord, this particular lady, my lord.
Happened, this is an inquiry of 2009.
That I admit, my lord, but Lord, she will kindly grant, my lord, after putting, my lord, any harsh conditions, my lord. She is all along ready to, my lord, appear before the concerned tribunal now, my lord. But she will impose any stringent condition, my lord.
Okay, we're dismissing it. Past orders in the chambers. May not be uploaded today. We have some work at the second half, so perhaps tomorrow morning it will be uploaded.
My lord, in fact, my lord, there are some, my lord, 2-3 cases, my lord, where this honorable court allowed us, my lord, to,
You can produce those.
my lord, will produce the. Lord, she will kindly consider and take note of those decisions.
For admission, supplementary item 15.
Instruction was not for family, Mr. Raman, as far as one, the department six father 1 month time, madam.
How much time?
1 month time, madam, because of the.
It is not permissible.
My lord,
So then we'll have to release him on bail. With conditions.
Because of the present war situation between Afghanistan and Pakistan.
Hmm.
But they, because of the present situation of the Afghanistan and Pakistan,
We'll give you time to keep it pending, but
Yeah.
in the meantime, he will be released with conditions. He was arrested at Chennai International Airport. Roman Can
6, fourth line.
You have typed it wrong in your petition at paragraph 3. That's why. Abdul Qayyum, son of Abdul ABTUL, Abdul Qayyum, QU, sorry, QAYUM. And he had entered India twice in the year 2021, having arrived from Afghanistan. Full stop. He has obtained Indian documents like Aadhaar card, PAN card, and also an Indian passport under the name of Muhammad MD Dilowar, DILOWAR, Dilowar Khan. Full stop. Next, in the meanwhile, the Madras High Court, by an order dated 13/2/2025, passed in criminal CRA, criminal, chief number 2899 of 2025, granted bail to the petitioner. However, in the meantime, the concerned authorities in the public within bracket foreigners dash Roman 1 bracket which department had issued a letter dated 6/2/2025 restraining the movement of the petitioner, who was directed to reside at a special camp identified and located by the district collector, Tiruchirappalli, TIRUCHIRAPPALLI, in the event of release from prison, till deportation. In the meantime, as foreigners tribunal was not found operational anywhere else in the country, except of Assam, and the petitioner projected himself to be a citizen of India to his Indian passport. Case of the petitioner was transferred to the Foreigners Tribunal, Nalbari-1, which is registered as FT within bracket capital N, NAL, bracket close, case number, again within bracket N, bracket close, 56 of 2025, page 43. Bearing DC reference numbers so and so. Next paragraph, the petitioner moved an application for bail before the said learned tribunal, which was rejected by order dated 18/12/2025. The said order has been put to challenge in this writ petition filed under Article 226 of the Constitution of India. Next paragraph. This court by order dated 19/1/2026, I had issued notice. Returnable on 21/1/2026. The matter was listed on 28/1/2026. And the direction was issued. Pass the following, in paragraph 5, pass the following order. Applying page 5, the earlier order of 28/1/26. Full stop. Accordingly, the learned CGC as well as the learned government advocate were directed to take appropriate steps. Sorry, not appropriate, necessary steps as may be required. Full stop. Thereafter, when the matter was listed on 17/2/2026, the learned CGC preparing for respondent number 1 had submitted that he had received instructions from the regional passport officer by email dated 2/2/2026, conveying that the fingerprints which were sent by CCB-1, Chennai in capital CBEFF format have been matched with the biometrics connected to passport number capital V numerical 1736451 of Muhammad MOHAMMED Dilawar Khan DILOWAR. As the petitioner was also holding a passport from the Islamic Republic of Afghanistan, the Ministry of External Affairs was made a party. The newly implemented Minister of External Affairs, New Delhi, is requested to provide information after doing the needful inquiry as to whether the biometrics connected to passport number V1736451 of Muhammad Dilawar DILOWAR Khan Oh, Mr. Roy, you were there. Last time we refrained from passing an order, I remembered now. We wanted steps from your side. So
From regional office, Lordship, I have been informed that we have talked to them, but it will
it's
take
okay,
some.
but we are not penning it down. The last
Lodge.
part of the order, we are not
Lodge.
penning it down.
Lodge.
That will, my lord, may prejudice me in my tribunal, for the tribunal.
You understand? We remembered it.
And if I can,
Like that last time. no?
and if I can place, my lord, the writ petition, my whole prayer is to allow me on to go on bail. Those things can be looked into by the tribunal. Now.
Then we can't pass the order, right? In interim, would the amount to allow of the rate petition.
My lord, then that aspect of the matter is okay.
That is- Then we hear the matter on merit.
Lodge.
Saturday, can we take it up?
Because, my lord, they will not be able to bring it on instructions. They need 1 month time, my lord, because there is a.
That was for different purpose.
Mhm.
Now, if you don't want that part of the order, then we hear the matter on merit.
Not my lord, your lordship may pass an interim and let this matter remain.
No, interim would amount to allow the final relief. That's
Because if I don't place that before lordship, that will be a suppression of facts. And the
We
prayer is
understand.
itself, I found.
We understand, we're not that. We were a bit carried away, then we reminded ourselves of what has happened on the last day.
My lord. And my lord, what I understand, once I have been allowed to go on bail, taking into consideration the detention order. The detention order
Take that
also
into
to
consideration, Saturday, if it's not.
Saturday, will it be tomorrow, my lord? Tomorrow.
Tomorrow, no.
Tuesday, Lodge.
This motion that is open,
Tuesday, Lodge.
Tuesday.
Lodge. Tuesday to be. Tuesday.
Tuesday. But don't write off this. Tuesday. But there are also the represented. This is the matter on 10/3/2026. Where an attempt would be made for final submission of the matter.
On 10th, my lord.